September this year marks 12 months since the launch of the sexual violence case management pilot, which commenced on the 2nd of September last year. The practice changes brought by the pilot program are underpinned by the Practice Direction number 3 of 2025. No doubt you all know it off by heart. And that sets out the protocol for the case management of sexual offence proceedings in Brisbane and Ipswich, and best practice principles for everywhere else in Queensland. The protocol supports the front loading of matters by encouraging early dialogue between parties to support early identification and resolution of pretrial issues, and early and coordinated listing of pretrial hearings to reduce delays in the whole process. At its core, the pilot aims to improve the experience of complainants and witnesses in sexual violence matters, while at the same time preserving fundamental rights of the defendant and maintaining the highest standards of fairness. A quick recap: the catalyst for the change was in 2022 in the second report of the Women's Safety and Justice Task Force, which made recommendations to improve case management of sexual offence proceedings in our court, the District Court. The task force identified that sexual offences take significantly longer to resolve than other cases, and that long delays in trial proceedings and multiple adjournments are a major factor in increasing the trauma of the trial process for victim survivors. Our court's data was showing that sexual offence matters take approximately twice as long to finalise than other offence types. The task force called on the District Court, in consultation with stakeholders, to implement improved case management to increase efficiency, reduce the number of court appearances and the number of matters that unnecessarily progress to hearing, and improve the effectiveness and quality of responses to victim and witnesses. It was recommended that any process should incorporate specialist lists, case management, and mediated case conferencing. Key features of the case management pilot, I'll go over these quickly, but I take it you're familiar with these now, include lists that enable dedicated coordination by the court of Chapter 22 and Chapter 32 offences, new court events, the case review hearing, trial readiness hearing, directions hearing that facilitate court oversight, and active case management. The case review hearings are designed to encourage parties to turn their minds early in the matter to the proceeding, to meet disclosure obligations on the one hand, confer with the other party, submit necessary applications and set timelines. The idea being that the trial will be listed from presentation of the indictment. Other features are that there's a requirement for parties to complete forms. They provide information to the court, which is collated in a summary by the case managers for the trial judge, for the case review hearing judge. There is, of course, a mediated case conferencing to facilitate trial preparation, and a commitment, and this has been really key and useful in the success of the process so far, a commitment to early allocation and continuity of the Crown Prosecutor to ensure that there's consistent case progression and minimised delays that might happen if there has to be rebriefing. There's also been a new grant of aid from Legal Aid to support completion of forms and solicitor and counsel appearances at court events. Now, I can give you some early data insights, but the caveat is that the program's really only operating for 12 months, and it's really early to start calling trends. But here are some figures. As of 30 September 2025, 364 matters had been added to the sexual violence list across the Brisbane and Ipswich pilot districts. 254 were still being actively managed, including those awaiting sentence, and 110 had been finalised. Brisbane accounted for 179 active cases, 87 matters finalised. Ipswich accounted for 75 active cases, 23 finalised. The matters are considered finalised when the matter is sentenced, or the defendant's acquitted, or there's been a nolle prosequi. There have been some delays. When an indictment is only placed on the sexual violence list at the second or third or fourth mention after presentation. This is predominantly due to funding or some other administrative issue. It's preferable that matters be placed on the sexual violence list at presentation, unless it is clear and stated then that there will be a plea of guilty. I've been guilty of this myself. It's really tempting to say, okay, come back in 3 or 4 weeks and then see whether we're going on to the list. But sending it straight to the list enables case management to commence, even where you think it might resolve. This minimises unintended delays when negotiations are delayed or fall over. Sending an indictment to the list does not stop negotiation. Having the parties talk early is the point. Now, of the 110 sexual violence list matters that have been finalised to 30 September, there were 17 trials, 64 pleas of guilty, 27 nollies. 2 were referred to the Adult Restorative Justice Conferencing. And I said this, Katie, before, this is early data. And as more trials proceed, no doubt they will take up a greater proportion of finalisations, the trials. In terms of resolution prior to trial, the data on pre-trial resolutions that shows that cases are resolving by nolle after 4 or 5 months of presentation, and guilty pleas are coming through around 2 months after indictment presentation. Anecdotally, it appears that more matters are resolving prior to trial, and that might be attributable to early allocation of trial counsel, early consideration of the matter and relevant applications made at case reviews, and earlier and productive negotiations between parties at or before the mediated case conference. Now, there's a few numbers on that slide. The practice direction requires for a case review hearing to be held within 4 weeks of presentation of indictment. As of 30 September this year, 316 case review hearings have been held in Brisbane and Ipswich. And of these, the median number of weeks from being added to the list is 4.6 weeks. Case review hearings that are listed are also clustering around the 4 to 5 week time frame. So from the indictment to trial, that period, the practice direction requires that the first day of trial take place within 8 months of presentation of indictment. And so far, of the 17 sexual violence list trials that have been held, the median time from indictment presentation to first day of trial was 8 months. The trial listings are pushing out slightly. So I'm talking about the ones that have happened so far, 8 months, but they're starting to push out to 8.9 months. And again, the finalisation of 17 trials makes the data less stable and difficult to interpret. But overall, the timeframes are at least trending in a positive direction. And your own experience will tell you that that's, if we can keep up anything like that, that's a dramatically good advance. Of the 316 case review hearings held to date, 46% were held within 4 weeks of being added to the list. 84% have been held within 6 weeks. Now, there are valid reasons, it's accepted, why matters aren't brought for case review hearing within the 4-week period. Sometimes parties flag the matter for earlier resolution and they want to prepare and respond to submissions. Sometimes it's to support Crown Prosecutor availability and early allocation and continuity of trial counsel. So these things can take longer to get into place. It could be due to delays caused by challenges with access to defendants in custody or to locating complainants. You should seek to comply with the prescribed 4-week timeframe where it's possible and balance this to flexibly apply the case management protocol to a given matter. This is to reduce unnecessary appearances and costs. So case management is not a one-size-fits-all approach, but the goal is to improve consistency and strive for the best practice. In both Brisbane and Ipswich, practitioners are accommodated to list the case review hearing at a time suitable to the case. I'm glad to be able to present this report to the profession because the process doesn't work without the profession's buy-in. And I've already acknowledged the particular buy-in from the DPP, but it is the whole profession that can make this work. So you're entitled to know how it's going. And these are early figures, but they're worth talking about, I think. There's been an analysis to look at the period of 18 to 36 months before the implementation of the pilot and the 12 months post-implementation. That's what the pre and post analysis means. Took me a while, but there we are. The data shows an increase in the proportion of sexual violence offence matters listed for sentence at indictment presentation, an increase of 54% of matters listed for sentence from 2022 to 3 to 2024 to 5. The observed increase in sentence results might be a consequence of early engagement by trial counsel and the additional scrutiny brought by the case management pilot. Additional data and time will provide further insights. I might tell you these things too. Between the 1st of September 2024 and the 31st of August 2025, so 12 months, 413 indictments charging a sexual violence offence were presented. 41, 10%, were listed for sentence at indictment. In the previous 12 months, 450 indictments charging a sexual violence offence were presented. 6%, 23 of them, were listed for sentence. In the previous month, 12 months before that, from September 22 to August 23, 472 indictments, a greater number of indictments, charging a sexual violence offence were presented. 7%, 33, were listed for sentence. So at the risk of spelling out what I've just told you, you've heard a lot of numbers. It was 7%, it was then 6%, it was in this last year 10% of indictments going to sentence from presentation. Between that 12 months period I just talked about, of the 17 trials held, the median number of court events held was 10. Between September 21 and September 24, of the 422 sexual offence trials held, the median number of court events was 12. So it's a little improvement, but it's still an improvement from 12 pre-trial events to 10. The median number of court events for matters on the sexual violence list finalised by trial has decreased by 17% relative to sexual offence trials during that period I just mentioned, 21 to 24. But again, with only 17 trials done, the data requires more input to be reliably interpreted. The 17 trials that are run to date are those that have largely run without any issues. They've really been listed and been dealt with. With time, the median number of sexual violence list court events might change as the data becomes more representative. The court's aware that increased court appearances and associated costs are concerning to defence practitioners. But so far as we can measure, the data suggests a slight downward trend in the number of events and appearances. The data does not capture the frequency of appearances relative to the overall matter length. Anecdotally, case management appears to increase the early intensity of court events. That is, I've seen an extracted example of this where there's a long time between presentation and trial and a lot of court events spread over time. The point that we're trying to make here is, and this is anecdotal, is that there is a concentration of events earlier. And it's the design of our timeline set out in the practice direction, that there be an early concentration and then there can be a considerable gap between the trial readiness hearing and the trial. So the concentration is within the first 2 to 3 months after presentation. Okay. Now, for the moment, I'm going to hand you over to Alexis to take you through her updates about what's happening in the mediated case conferences. Thanks, Alexis.
Thank you, Chief Judge. As most of you are aware, the mediated case conference is a step in the case management process, and it was one of the recommendations of the task force that it be implemented to assist with the overall aims of the sexual violence case management pilot to better manage proceedings for sexual violence matters in the district court and to minimise delay in the court process. I'm not going to labour over this slide too greatly, as most of you who are here have participated in a conference, but I did want to highlight that the mediated case conference is something that must be held 2 weeks prior to the pre-recording of a complainant's evidence or the trial readiness hearing. So it's really the timeliness of when the mediated case conference is being held that is, in my view, having some impact on matters resolving in an earlier time. Practice Direction 3 of 2024 at paragraph 7.3 outlines the purpose of the mediated case conference. It is a without prejudice opportunity for the parties to narrow issues, settle agreed facts, test the strengths and weaknesses of their respective cases, and for the prosecution to provide a draft trial plan and indications as to sentence. The Practice Direction also sets out the case conference registrar role. It's a senior registrar. It's not a judicial registrar, and that's why I will invite parties to prepare consent orders so that they can then be placed on the court file and considered by the sexual violence list judge. And then if parties aren't attending to those matters, they can be enforced in that way. In some matters, rather than having the parties prepare consent orders, will arrange for notations to be placed on the court file so that they can then still be considered by the sexual violence list judge at future mentions of the matters. The next slide here. Sorry, I keep going the wrong way. Again, just sets out some early data insights about the numbers of mediated case conferences which have been held. So you'll see that there have been 121 mediated case conferences held. Of those that were held, 92 of those were in Brisbane and 29 were in Ipswich. Consent orders have been made in 39 matters and there are agreed actions in 78 of the matters. There has been generally an increasing number of mediated case conferences held per month. I'll just note that September is a bit of an aberration as I had taken some leave in that month, and that accounts for some of the discrepancy there in what is otherwise a trend where they're increasing over time. What we have also noticed is that more conferences are often scheduled than will ultimately proceed, and that allows pre-trial hearings that might arise through discussions that are occurring between the parties to be scheduled, and the mediated case conference may need to be adjourned to allow those other scheduled events to occur before the conference proceeds. Anecdotally, matters appear to be resolving close in time to the mediated case conference. This is something that the data team will be looking at to see if we can capture that. Overall, the average length of conferences has been about 28 minutes. So for those who are coming along, that's an average, but of course there are matters which proceed for longer than that and some which are shorter than that. We've also been having defendants attending conferences. And at this stage, we've had 8 defendants attending in person. I just wanted to take you through some of the trends which I've noticed. And the first that I wanted to raise was the effectiveness in appropriate matters of the adult restorative justice process. There have been 12 matters in the course of the last 12 months where it was raised by me or by the parties during the course of the conference process. 6 of those matters have been the subject of referrals. 1 was rejected, 1 was successful, and 4 of those remain pending. There are also 6 pending an update on whether a referral has been accepted for mediation but has otherwise been agreed to by both parties. I have been informed, though, that the recent expansion of the adult restorative justice conferencing service to accept referrals for what are referred to as high-risk matters, which include offences of sexual violence, hasn't continued beyond the 30th of September 2025. So unfortunately, the availability of this potential resolution of matters moving forward in similar suitable cases will be limited to only those where defence can privately fund mediation. As I understand it, the response from the service was that they have prioritised the expansion of the mediation service statewide, and the 2-year pilot that was conducted didn't have sufficient data for them to convince the government to extend the funding beyond the pilot period, which is a very disappointing outcome. I just wanted to focus on some of the trends that I've noticed that have occurred to focus on the aims of the pilot and in particular the mediated case conference. So one of those is to narrow issues and settle agreed facts. It is, of course, a process that's designed to be without prejudice, without any obligation on the legal representatives for the defendant to reveal the nature of the defence at trial. However, I've certainly observed a willingness of defence counsel in many conferences to at least give an indication of the general nature of the defence, even where that's not clear necessarily from a defendant's record of interview or from the focus of cross-examination and committal. And this, of course, has the effect of narrowing issues for trial and reducing the number of witnesses potentially required. And it's months earlier than would have occurred ordinarily. So some common examples have included where the defence has identified the issue for trial as being one of consent or mistake of factors to consent. The Defence Counsel have been able to confirm that DNA evidence isn't required. They've been able to consider admissions to eliminate the need to call particular witnesses for trial, or they may have confirmed that identity is not an issue in dispute. The Crown prosecutors have also come prepared to discuss, or in cases where not yet been considered, at least agreed to confirm an agreed date prior to trial aspects of the evidence, and that includes uncharged acts, identifying sexual interest evidence, discreditable conduct, relationship evidence. And those are matters that the parties have been able to discuss during the course of the conference so that it isolates precisely what's to be led and the purpose for which it's to be led. And the Crown have also now had to consider whether an application for leave 14 days prior to the complainant giving their evidence is required to lead evidence from the complainant of either consensual or non-consensual sexual activity which doesn't relate to the acts that have been charged. And I really wanted to use this opportunity to demonstrate how the overall aims of the pilot are being achieved through the mediated case conference by using some de-identified case examples. Some people who may have attended a conference may have come and spent 10 minutes potentially with me where the matter is straightforward. It might have one complainant, one charge on the indictment. The parties are engaging in useful discussions already, and there's very little progress that's made through the course of the conference. But there are certainly examples that I can provide to you, de-identified of course, that suggest that the parties are using this particular part of the process in a way that's quite effective. So the first case example I wanted to use was one where there was an independent assessment that I was able to make of the strength of the Crown case and an area of weakness in the Crown case, which ultimately led to an early resolution. I won't provide the specific dates, so it's less easily identifiable. But in this particular matter, the indictment was presented at the end of October of 2024. At the case review hearing that was at the end of November of 2024, the matter was listed for trial on the 1st of September of this year. The mediated case conference was scheduled for the 31st of March. In this case, the defendant was in custody. I was able to review the material, and it was quite clear that the defendant had made very extensive admissions to offending against this particular complainant in the record of interview. I was able to make contact with Defence Counsel and suggested that the defendant be produced from custody, and that was facilitated. I was also able to identify that there was a potential issue with the Crown case in relation to the commencement of the maintaining period. And so those were things that were discussed in the course of the mediated case conference. Defence Counsel was able to, in fact, conference with the defendant during the mediated case conference, and that one particular sticking point for resolution was discussed by me with the Crown prosecutor. There was an agreement that Defence would send a formal submission by a particular date, and the Crown had agreed to respond by a particular date. When the matter was next mentioned in May, the parties again had noted that there was a very constructive mediated case conference that was held and the matter would resolve, but they required some additional time. But towards the end of May, it was listed for a mention of appearance required, and the defendant was arraigned following those successful negotiations. And in fact, the defendant was then sentenced in the middle of last month. The second example that I wanted to refer to was, again, another matter where I was able to independently assess the strength of the Crown case, and that was also a matter which led to some early resolution. This was a matter where the indictment was presented towards the end of December of 2024. The case review hearing was held towards the end of January, and the matter had been listed for trial in the middle of November of this year. This was a matter which required some additional time because there was PCC applications which needed to be made together with a severance application. There was also some need to shift the pre-recording from June to accommodate issues which arose with the PCC application. And ultimately, it was rescheduled for the end of August. Once the PCC Stage 2 issue had been determined, within 6 days, the mediated case conference was held. In the course of that particular matter, I was able to make some comments to Defence Counsel about the challenges that the defendant would face in this particular trial. This was a matter involving 2 complainants. One of those had some indication of being the person that was identified in some child exploitation images that had been created by this particular defendant, and that was something which I was obviously able to say would cause some significant challenges for defence at trial. And I was able to receive some feedback directly from Defence Counsel saying that they were able to utilise the comments that I had made in that forum, given that I'm someone who's independently reviewing the matter, to assist in the conference that he was holding with the defendant, and that ultimately it resolved to a plea to amended charges, and that occurred 10 days later. And the defendant was then arraigned and the matter's listed for sentence. The third example I wanted to take you through was a matter where there was an early conference held with the complainant, which was able to identify some issues with the Crown case. And again, this was a matter where the indictment was presented towards the end of December last year. And again, the case review hearing was heard towards the end of January, and the matter was listed for a pre-recording on the 24th of April. I held the mediated case conference early in April. In the course of the conference, I'd encouraged the Crown Prosecutor to consider an earlier conference with the complainant. This was a particular matter where the issue at trial was consent in relation to a particular sexual act in the course of consensual sexual activity between the complainant and defendant who had been in a relationship. Defence Counsel had also in that context sent a submission where the defendant had offered to participate in justice mediation, and the Crown Prosecutor was of the belief at the time that there were certain charges incapable of being the subject of a reference. The Crown Prosecutor had agreed to conduct a conference with the complainant the following day, and that ultimately led to the Crown discontinuing the charges. The matter was listed by the parties for a directions hearing for case management, and given that change in the complainant's evidence, the pre-recording was discontinued, was delisted, and then a nolle was entered. One of course, the broader aims of the the sexual violence pilot and the mediated case conference in particular is minimising delay, and I wanted to draw your attention to these 4 examples of how it's working in progress and how the overall aim is being achieved. So the first matter was the parties had in fact used the mediated case conference as an opportunity to negotiate. This was one of the matters where the defendant was produced from custody to participate in the mediated case conference. The Crown Prosecutor had also arranged for the complainant to be available in one of the safe rooms at the court so that they could also be consulted in the course of those negotiations. The parties were able to successfully negotiate the charges within the conference process and agree on a factual basis for sentence on the day of the conference. And the defendant was then arraigned the very next day. That was facilitated by the team. The second case was where we received some feedback that it was in fact the preparation for the mediated case conference that provided the early opportunity for resolution. The parties in this matter had booked the mediated case conference the day before the conference was scheduled. When we were trying to obtain materials from the parties, we'd received confirmation that the matter had resolved, specifically because the parties were having to prepare for the mediated case conference. That then enabled the team to administratively delist the pre-recording, and the arraignment was listed administratively. The third matter was a successful alternative resolution reference within 8 months of the indictment presentation. Again, this was a matter where the indictment was presented towards the end of November of last year. At the case review hearing held in February, the trial was listed for the 1st of September. Towards the end of April, I had the mediated case conference. It was raised by me in the course of that conference whether the parties had considered whether this was a suitable matter for a referral. There had been an offer pre-committal made by defence to make that reference. However, the Crown Prosecutor had understood that it was not an acceptance of wrongdoing, which during the conference, Defence Counsel was able to make contact with the defendant, and it was confirmed that that wasn't in fact the case. A formal submission was made. There was a proposed amendment made to the schedule of facts, and it was agreed that the Crown Prosecutor would then conference with the complainant and reconsider that submission. Within 3 months, at the directions hearing for case management, which the parties brought on, it was confirmed that the mediation had in fact been held. It was successful, and the Crown was able to enter a nollie, and the defendant was discharged. That final example that I wanted to highlight is one where, again, we'd facilitated the production of the defendant in custody, which enabled some early resolution. This was, again, a matter where the mediated case conference was convened 2 weeks prior to the trial readiness hearing. This was a matter where the defendant required an Auslan interpreter and was also in custody. So it required us to arrange for the production of the defendant and negotiate with defence to have an Auslan interpreter available for the mediated case conference. Defence Counsel during the course of that was able to obviously take instructions from the defendant with the benefit of the interpreter, and an oral submission was made to the Crown Prosecutor in the matter. And then at the trial readiness hearing, that submission had been accepted and a sentence was listed 2 days after. So I hope that you'll see that these are some instances where this is a very effective process, and for those who have otherwise attended what may have been quite a short conference, consider other ways in which this process can be utilised for any matters that are appropriate. I'll now hand back to the Chief Judge to provide some further insights.
We're already at the time that we thought we would finish, so I'm sorry about that. I just mean if you have to leave, you have to leave. But I wanted to outline a number of things. It's clear from what Alexis has said that mediated case conferencing is going some way to narrowing issues and helping progress cases. It never was the stated aim to resolve cases, just to narrow issues. But it really does seem that the early attention to the case is getting earlier resolutions. Building on the early data insights and the observations of the mediated case conferencing, I want to now overview some of the early challenges and achievements of the pilot. The program, led by Lindsay Franklin Brown, seeks to promote continuous improvement through an established governance process. Some of you are well aware of this because you take part in it. These include a steering committee that provides strategic oversight for the pilot, which I chair, and which is attended by senior representatives of key organisations, the DPP, Legal Aid, Bar Association and the Queensland Law Society, representatives of victims groups. Then there are the local operational working groups, which provide a forum for feedback and problem solving, and that allows for issues affecting stakeholders to be aired and raised up through to the steering committee. Some of those issues are reflected in what I'm about to go to, and also thank you to those who have provided questions on notice for us. So because I expect to fairly densely tell you some information which might answer some of the questions that have been given and that you might have, I'll get straight onto it. One of the concerns is the increased handling of briefs and inadequate funding. You have reported an increase in the number of times you must handle and review a brief due to the additional court events brought by the practice direction. And this requires, that leads up to the case review hearing before the mediated case conference and then the pre-recording or trial. This requires the person appearing at the review or the conference to refamiliarise themselves with the details of the matter each time. And that is time consuming and may be thought to be inefficient. And if it's not privately funded, that this is compounded by the additional workload not being reflected in a legal aid funding model. So these are the issues that are being raised. I'm grateful that Kerry Bickle, who is the Director of Criminal Law Services at Legal Aid Queensland, is listening and can hear. Kerry, can you hear me?
I can, thank you.
Kerry, is there something you'd like to say to the practitioners about the legal aid responses to the funding needs?
Thank you, Chief Judge. I just wanted to, by way of background, indicate that legal aid didn't receive any additional government funding to support the additional services associated with the sexual violence case management pilot and the associated practice direction. However, in response to the release of the practice direction, as you've already pointed out, legal aid funded through existing internal resources the additional grants to reflect or try to reflect the additional case management requirements of it. These were developed out of our base legal aid rates and scale of fees, and it's accepted that our base rates are not competitive with commercial rates. To help practitioners understand the grants of legal aid available through the pilots in Brisbane and Ipswich, we have put together a fact sheet because my experience in the governance committees that you referred to has reflected to a degree some misunderstanding, but also wanting to highlight that we don't offer, unfortunately, commercial rates through these processes. But there is a fact sheet available. This has previously been distributed to our preferred supplier network and will again be distributed this week in light of the information session today to place some context, but also hard copies are available for those in attendance at the Banco Court today. In short, it's an additional pilot grant of aid available to solicitors and barristers in these matters. They reflect what's anticipated to be additional hours involved in completing the forms, attending the case review hearing for the solicitor and the mediated case conference for solicitors and barristers, effectively $525 solicitors, $420 barristers. And these are in addition to a number of existing district court grants, including the district court preparation grant available immediately upon a case being committed, pre-trial hearing grants of aid, including PCC applications, and pre-record grants of aid available for each pre-trial hearing and each pre-recording. It's also in addition to the district court day one of trial grant, which is available as soon as a client has signed instructions for trial, and the additional days of trial grants. Now, in the absence of additional funding to legal aid, like all other grants of aid, a defendant will need to be financially eligible for legal aid for LAQ to fund legal representation in the pilot. And if practitioners have any questions regarding available grants of aid, I would encourage solicitors who are preferred suppliers to review the circulated fact sheet or to reach out to their usual grants team for information. And for barristers who have grants inquiries, they're not quite sure what they can and can't apply for or funding they can claim, I would encourage them to contact our grants division through a recently created grants contacts for barristers, and the flyer relating to that is also available in the Banco Court today. And yeah, for those attending in person. If you've got concerns about the level of funding or legal aid's response We would encourage you to raise this with your respective professional bodies and have them communicate these directly with our CEO. But before you do, I would encourage you to just take the time to review what grants are available. And finally, I'm sorry, this is not a particularly interesting topic, but we are encouraging to assist us in evaluating any shortcomings. We are asking practitioners to ensure they claim for all the work. Those who are legally representing legally aided clients, please claim all your work, including additional mentions, conferences and negotiations that have been necessary as part of the pilot process, over and above what is paid as part of the above standard grants that I've already mentioned. And this will give us some visibility of the actual cost and could influence reviews of the grants as they stand. So thank you.
Thanks very much, Kerry. Thank you. The program team has also worked with the Bar Association to develop a cost and time tracking questionnaire to support the collection of data to facilitate future funding changes. And there's a link to the questionnaire on the court's website, the Queensland Court's website. In a recent update, it will be emailed upon finalisation of any matter on the sexual violence list. And don't forget that the trial readiness hearing, a court event introduced by the practice direction, may be delisted if the matter is ready to proceed to trial. The data is that 10% of finalised matters have sought to delist the trial readiness hearing via the form. There is flexibility in the case management approach and an understanding that additional court events are designed to support and facilitate case progression. The next thing is there's been early confusion about the required attendance at case review hearings. The practice direction requires that the person appearing must be able to speak to pre-trial applications and issues, but things about special witness provisions, readiness to proceed with the pre-recording, trial length, counsel availability, those sorts of things. Solicitors with carriage of a matter, therefore, may appear at the case review hearing, but you must have adequate instructions. And that really means that a town agent or a legal officer who can't speak to the issues means that the case review hearing doesn't achieve what it should achieve. It has been observed that case review hearings tend to run more smoothly when counsel who is briefed to appear at trials appear for both sides. But I repeat, that's not what's required. But what is required is the person who comes knows the case. To assist in facilitating such appearances, the sexual violence list in Brisbane have granted a standing leave for parties to appear by telephone at sexual violence list events. And you just have to get in touch with the case manager to do that. The next issue that's been raised a bit is some uncertainty about the correct procedure for subpoenaing protected counselling communication evidence. That situation has not necessarily been helped by the introduction of Section 14, capital H brackets 2, capital A of the Evidence Act. And the definition of PCC is so wide. These issues can cause delays. Over the past 12 months, there has been some consultation with some judges by the government on protected counselling communication laws. I'm advised that the feedback is being considered by the government. I think it's been underway for a long time, but we have no information about what, if any, changes to the Act will be made. It's also understood that complying with the practice direction to fit in both a so-called stage 1 and stage 2 hearing can be a challenge. The team has developed a precedent email to encourage timely filing of PCC applications. Case managers are monitoring court listings to ensure that stage 1 hearings are set 2 to 4 weeks out to enable the Crown to issue the Section 14 capital G notice, and for Women's Legal Service or Legal Aid to engage the counselled person and brief counsel. The other thing that seems still to cause some consternation is the direction, the practice direction, including the directions hearing, called directions hearing bracket evidence of witness. Paragraphs 40 to 42 of the practice direction, as per them, the purpose of the directions hearing is to set ground rules for the examination and cross-examination of a special witness. And this includes things like manner of questioning, duration of questioning, questions that may or may not be put, that kind of issue. The practice direction is, by now I think everybody knows, reflects amendments to Section 21 capital A, B of the Evidence Act that commenced in this September, in which complainants of sexual violence matters are to be afforded hearings to establish ground rules for the giving of evidence. It's in the Act. The court didn't make this up. To standardise the process for these directions hearings and to increase engagement, the sexual violence team has formulated questions which have been added to the case summaries for the judges. Now, don't forget this, the directions hearing should occur after a mediated case conference, and it can be held on the same day as the mediated case conference. It won't be heard by the registrar, you'll go to court, but you can get the two events done on one day. And that also enables any orders agreed during the conference to be considered by the judge during the directions hearing, and also allows the case conference registrar to recommend the delisting of a directions hearing where it is deemed not to be required. The directions may be held 1 or 2 weeks before or on the morning of a pre-recording. In Brisbane, where a matter has an intermediary directions hearing, you do not also need the direction hearing for examination of the special or affected child witness, because of course the hearings achieve the same aim. You may seek not to list a directions hearing at the case review if an application for an intermediary is underway. This is all to say there is flexibility in the process. Where there is no pre-recording, the directions hearing may be combined with the trial review, which is usually 10 days before the trial. And that might alleviate concerns around multiple or unnecessary appearances for the parties. Another issue raised in the questions and has been of some concern to all of us is delays in the magistrates' court and in committal proceedings, particularly due to lengthy delays with disclosure of the brief of evidence. The data indicates that for the sexual violence list matters, the median number of days from first appearance in the magistrates' court to presentation of indictment is 13 months. We know there are concerns about how courts are addressing delay across the jurisdictions. Fortunately for us, Deputy Chief Magistrate Gett is in the audience, and he can speak to what the Magistrates Court is doing about this. Thanks.
Thanks, Chief Judge. So, Practice Direction 11 of 2024 established a sexual assault offence call-over just for Brisbane. It's a pilot program that's amenable to a multi-magistrates court to determine whether we can make inroads and expediting matters through the court, and hopefully to work in sync with the district court specialist call-overs and program. What is the major delay? It's pre-preparation, without a doubt. We have 3 prosecuting agencies that appear for sexual assault matters, direct prosecution, police, which govern a lot of matters, as well as on occasions Commonwealth MVP. So delay is endemic in preparation of brief. The standard time frame of 5 weeks is rarely met. That's not necessarily criticism. And then matters have to go ordinarily through multiple submissions and the like. And then it has to go potentially through an application cross process as to whether or not witnesses crossed or witnesses are to be crossed, and then the committal itself. Interlaced amongst all of that, why we established that call over was a number of the Evidence Act reforms from the task force, and you'll see, for example, coincidence evidence, tendency evidence, almost always they apply in the Magistrates Court. So the application for intermediaries can be made. Applications for sexual reputation can be made in the Magistrates Court. It's often overlooked by practitioners that those applications are applicable in the Magistrates Court. For special witnesses, victims of sexual offences, special witness provisions apply in the Magistrates Court, where we're now required, where the first step was taken after the 20th of September this year, that we require to video record. Previously, I think there was an understanding that Magistrates Court didn't have as many applications. Now it's cast in the mandatory. So we're burdened with making sure all those boxes are ticked, because many are cast in the mandatory. Some are on the court's own motion as well. So, for example, the expert panel version 2, that's applicable in Magistrates Court as well at committal. So the number of interlocutory steps from arrest, which can arise a non-publication order, can arise immediately, 1 minute past the person being arrested, right through to the committal itself, sees numerous steps that we have to turn our mind to, but managing, getting the brief done, settling people's legal representation where people often change, and often where counsel are not involved, can inherently cause significant delays. The other thing is we're seeing just a large increase in the number of matters coming through the courts. So we had to establish a call over. Ordinarily, for the criminal call over, we used to have it in Brisbane. It's about 260 matters per week. We've now put that call over to once a month, sexual assault call over just for Brisbane. We're averaging about 120 to 160 matters every call over. So they're large lists, and we're burdened by congestion. And remember, it's not an isolated crime type, because there's domestic violence matters that are clogging up the courts as well. Other matters that have caused significant delays on just court allocations and the like. So we're readily aware and acutely aware of those delays. And then, of course, there's the DNA delay, which may apply in many matters.
Thank you. Thanks, Deputy Chief Magistrate. Now, about the achievements, I've already hinted that I think the early signs are that the pilot is achieving exactly what it was meant to, which is some greater certainty for the parties and an identifiably shorter timeline for the whole proceeding. Case managers really add value to the proceedings. That means the parties have a point of contact in the court, and the case managers collate material which is beneficial to the judges, which means the whole proceeding goes better. Parties are completing the court forms as required. The parties are providing mutual availability ahead of case review hearings, and that speeds up listing. All these things could be done anyway without a praxis direction, but they haven't been done, and it's really good to see them being done. There are the new court events, including the case review hearing, the other court events. They do encourage early allocation of trial counsel, and that does result in earlier facilitated negotiations between parties, settling pre-trial issues earlier in the proceedings, and anecdotally, this is leading to earlier resolution. The local operational working groups are providing an effective forum for stakeholder engagement and feedback with issues and concerns raised during those meetings, which help the whole process continue all the time. So that's really all I wanted to say at this stage. Lindsay did want to speak to you about some changes. You're not going to speak anymore. Some changes to the forms that have been made, but will they be obvious on the website when people see them? The link has been updated. Yes. Just start talking.
The link has been updated on the court's website. So the case review form has been streamlined and made more efficient. We've heard the feedback that has come through from stakeholders, and hopefully when practitioners engage with that, they can see those improvements. We will circulate these slides so you can go through this in your own time and see what changes have been made by the program team.
All right. And the case managers, I don't know if people know what they look like. Should we?
So our case managers in the sexual violence case management pilot, we've got Bess Pascoe, who is sitting at the front of the room. And then we've also got Daniel Martin, who is sitting up the back here. And these are our case managers in Brisbane. And then Katrina Britton is our case manager in Ipswich. So I'm sure many of you have spoken to and engaged with our case managers, and I just encourage you to continue doing so. They're a fantastic resource that didn't exist prior to the case management pilot, and as Chief Judge said, they really support the efficient management of the sexual violence lists.
We won't talk at any length about the evaluation, but the process for evaluation has already started. An evaluation body has been appointed. It's really important for that evaluation too, that the bars exercise with the costs and time be completed as fully as possible. Because if it does add time and costs, then that should be exposed in the evaluation too. Then we were going to have any questions that you have. So we'll stay for questions if you have them. Are there any online questions? Okay.
The statistics you showed with the resolution as 27 dollars.
Yes.
The charge of the matters whole funds.
That's indictments.
Thank you.
That's the indictment, yeah. And so I no doubt often enough the charges change and, you know, there's some negotiation, but where there's a resolution, but it means the indictment.
And so there were 27 nollies after 27 discontinuances of full indictments after committal hearing, after the mediation, and after the process of followed through.
Was it? Yes. 17 ran to trial. This is out of 110. 17 ran to trial in the time we've already had. 64 were pleas of guilty. 27 were nollies. Yeah.
Thank you.
But see, that's just one of the good things about getting into it early. These things get looked at really closely and resolved.
I'm not sure what that reflects over the 110. My maths isn't good enough to work it out, but it's a substantial percentage of an entire nollie of a matter that have been through committal hearing, have had that sort of grand jury function performed by the director's office, determining whether there's a case that would be result in a conviction, then be mediated, then go through the court over process. That's a substantially high figure, isn't it, or not?
Yeah, it'll just be interesting to see. I just warn that these figures are early. Yeah, in 12 months' time, a whole lot more trials will have happened, and we don't really know what that percentage will be. It's still a surprising number, though, but we won't know what it will be in terms of a percentage of the whole body of work.
Negotiate as a solved process. I'm not sure if the question makes sense.
Yes. What would result in, please? Yes. Is there an answer? Do you have?
I mean, we will try to look at pre-post analysis with regard to the number of matters that resolve by way of nollie and by way of plea. So the way to answer that question is to look at the data prior to implementation of the pilot and post, and we will do our best to do that. But I think it's a good question to understand how the case management process is actually influencing and impacting the number of pleas that would have ordinarily happened anyway. So that's our best process for that, is pre-post analysis.
But the real effect, I think, that is sought is that the pleas that might ultimately have happened anyway happen quicker. They don't happen after somebody has been told they're giving evidence next Monday, and then on Sunday they're told, okay, you're giving evidence tomorrow, and then on Monday morning they come to court after, 2 years of anxiety to be told, oh, they've done a deal. You don't have to give evidence.
Yes, I agree with Chief Judge. I think the timing of when these early resolutions happen are really key in this process.
And I've just stated that from a complainant's point of view, but it is equally stressful for the punter who's facing an indictment. And it just occurred to me the other day, we talk so flippantly about an adjournment for all sorts of reasons. I don't mean we talk irresponsibly, but we're so used to that as we run the system. But the people charged, imagine being charged and then you're told, oh, well, in 6 or 8 months' time, you might get through the magistrate's court, or more likely 13 or 12, and then it'll take 4 months to get into the district court. But, we'll keep it moving. We'll get it out of there in 12 months if with any luck. That's agony for somebody who's charged. So it cuts all ways if we can tighten things up, give some certainty to everybody, and just some more identifiable timeline. And there are real challenges and there are the costs, and we know that we're all trying to work on that. But it's already showing that we're achieving this, and that's because everybody is buying in. I'll shut up and we'll adjourn for the evening. Thank you very much for coming.